Illinois Real Estate State Exam Prep. Question 1. A business offers to find apartments for renters in exchange for a fee. Why might Illinois licensing law be implicated during Casey's Evanston farm parcel file review? Option A. Rental minus finding services can involve regulated real estate activity when performed for compensation. Option B. Rental minus finding services are always exempt regardless of activity. Option C. Only sellers can trigger licensing law. Option D. The service becomes legal if no written records are kept. The correct answer is option A. Rental minus finding services can involve regulated real estate activity when performed for compensation. Rental minus finding and leasing minus related services may be regulated when performed for compensation. The activity is not automatically exempt. Licensing law is not limited to sales, and failing to keep records does not cure an unlicensed activity issue. Question 2. A settlement service provider offers a broker a hidden referral fee for steering buyers to that provider. Which federal concern is most likely during Morgan's Oak Park single-family home file review? Option A. Fixture classification. Option B. RESPA restrictions on kickbacks and unearned fees. Option C. Adverse possession. Option D. The rectangular survey system. The correct answer is option B. RESPA restrictions on kickbacks and unearned fees. RESPA addresses prohibited kickbacks and unearned fees involving settlement services. Fixtures, adverse possession, and land survey systems are unrelated to hidden settlement minus service referral payments. Question 3. A small rental property has annual net operating income of $36,000 and an indicated capitalization rate of 7%. What value is suggested by the income approach? Option A. $252,000. Option B. $5,143. Option C. $514,286. Option D. $257,143. The correct answer is option C. $514,286. The income approach using direct capitalization divides NOI by the capitalization rate. $36,000 divided by 7% equals about $514,286. The other answers multiply by the rate, treat the percent as a whole number, or cut the indicated value in half. Stressed about your Illinois real estate exam? We can take Illinois real estate exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. A consumer asks why a state real estate recovery fund might exist. Which purpose is closest during Riley's Elgin condominium unit file review? Option A. Guaranteeing every buyer a profit on resale. Option B. Paying all ordinary home repairs after closing. Option C. Replacing the need for broker licensing. Option D. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. The correct answer is option D. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Recovery funds are designed as limited consumer minus protection remedies for qualifying misconduct minus related losses. They do not guarantee investment profit, pay routine repairs, or replace licensing and discipline systems. Question 5. A buyer includes a sale minus home contingency in a purchase agreement. What is the main purpose of that clause? Option A. It gives the party a contractual condition that must be satisfied or waived under the agreement. Option B. It automatically gives the broker ownership of the property. Option C. It removes the need for mutual assent. Option D. It makes all deadlines meaningless. The correct answer is option A. It gives the party a contractual condition that must be satisfied or waived under the agreement. A contingency creates a condition that can affect whether the parties must proceed or may terminate under stated terms. It does not transfer ownership to the broker, replace mutual assent, or eliminate all contractual deadlines. Question 6. A property is worth $322,000 and has a loan balance of $129,000. Approximately how much equity does the owner have? Option A, $451,000. Option B, $193,000. Option C, $129,000. Option D, $257,600. The correct answer is option B, $193,000. Equity is the property's value minus debt secured by the property, so $322,000 minus $129,000 equals $193,000. The distractors add debt, report the loan balance, or use an unsupported percentage of value. Question 7. Morgan has completed high school and wants a first Illinois broker license after finishing coursework in Naperville. Which education path most directly satisfies the standard broker pre-minus license requirement? Option A, only a 15-hour leasing agent course. Option B, 45 hours of managing broker education without broker coursework. Option C, 60 hours of broker pre-minus license topics plus 15 hours of interactive applied real estate principles. Option D, a continuing education course completed after licensure. The correct answer is option C, 60 hours of broker pre-minus license topics plus 15 hours of interactive applied real estate principles. Illinois broker candidates in the standard path complete 75 class hours made up of 60 hours of broker topics and 15 hours of interactive applied principles. A leasing course is for residential leasing agents, managing broker education is a different license path, and continuing education applies after licensure rather than before the broker exam. Question 8. A contract identifies land using a meets and bounds description. Why are legal descriptions tested separately from street addresses? Option A, street addresses are always more legally precise. Option B, legal descriptions are used only for personal property. Option C, a legal description replaces the need for a seller's signature. Option D, a legal description is intended to identify the parcel with greater legal precision than a mailing address. The correct answer is option D. A legal description is intended to identify the parcel with greater legal precision than a mailing address. Legal descriptions identify the land for conveyance and title purposes, while street addresses are often practical but less precise. They apply to real property, not personal property, and they do not replace signature and contract requirements. Are you looking for Illinois real estate exam actual questions? Visit our website pokerexams.com to access Illinois real estate exam study guide with actual questions and answers. Scan the QR code or click the link in the description to get Illinois real estate exam answer key today. Question 9. A buyer purchases for $280,000, makes a 10% down payment, and has $3,500 in closing costs. About how much cash is needed at closing before credits? Option A, $31,500. Option B, $28,000. Option C, $3,500. Option D, $276,500. The correct answer is option A, $31,500. Cash needed combines the down payment and closing costs. 10% of $280,000 plus $3,500 equals $31,500. The other choices omit either the costs or the down payment, or subtract costs from the price incorrectly. Question 10. Drew failed one portion of the Illinois broker licensing exam several times during the eligibility period. After the fourth unsuccessful attempt, what must happen before testing again? Option A. The candidate may immediately test an unlimited number of times. Option B. The candidate must retake the required broker pre-minus license education before retesting. Option C. Only the national portion must be retaken without additional education. Option D. The candidate automatically receives a leasing agent license. The correct answer is option B. The candidate must retake the required broker pre-minus license education before retesting. Illinois exam rules allow broker candidates up to 4 attempts during the eligibility period. After a fourth failed attempt, the candidate must complete the required pre-minus license education again before retaking the examination. Unlimited attempts, partial automatic exemptions, and automatic licensure are not supported. Question 11. A tenant with a disability requests a reasonable accommodation to use the rental property. How should the property manager analyze the request during Alex's Belleville Suburban Ranch home file review? Option A. Deny every accommodation to keep rules identical. Option B. Approve only accommodations requested by owners. Option C. Evaluate whether the request is reasonable and necessary for equal use and enjoyment of the housing. Option D. Treat the request as an automatic eviction notice. The correct answer is option C. Evaluate whether the request is reasonable and necessary for equal use and enjoyment of the housing. Fair housing analysis considers whether an accommodation is reasonable and related to the tenant's disability minus related needs. Blanket denial, owner minus only approval standards, or treating the request as eviction would conflict with the purpose of accommodation rules. Question 12. A rental property has NOI of $26,000 and a value estimate of $320,000. Approximately what capitalization rate is indicated? Option A, 4.1%. Option B, 11.1%. Option C, 12.3%. Option D, 8.1%. The correct answer is option D, 8.1%. The capitalization rate is NOI divided by value, so $26,000 divided by $320,000 is about 8.1%. The other answers have the rate, add unsupported points, or invert the formula. Question 13. Blair negotiates the sale of another person's lakefront cottage for a promised fee. Under Illinois licensing principles, why would this activity generally require a real estate license? Option A. It involves brokerage activity for compensation on behalf of another person. Option B. It is allowed without a license if the property is residential. Option C. It is exempt whenever the fee is paid after closing. Option D. It requires only a notary commission instead of a real estate license. The correct answer is option A. It involves brokerage activity for compensation on behalf of another person. Negotiating real estate transactions for another person for compensation is a core licensed brokerage activity. Residential status, delayed payment, or holding an unrelated notary commission does not remove the need for the proper real estate license. Question 14. Kendall is comparing loan terms and closing disclosures. Which federal lending framework is commonly tested with residential mortgage transactions? Option A. The Statute of Descent and Distribution. Option B. TRID and related TILA-RESPA disclosure rules. Option C. The rule against perpetuities only. Option D. A zoning variance issued by the City Council. The correct answer is option B. TRID and related TILA-RESPA disclosure rules. Residential mortgage questions often test TILA, RESPA, and integrated TRID disclosures that help borrowers compare costs and terms. The other choices deal with inheritance, property-law doctrines, or land-use approvals rather than consumer mortgage disclosure. Question 15. A buyer obtains a loan of $163,799 on a property appraised at $210,000. Approximately what is the loan minus to minus value ratio? Option A, 22%. Option B, 88%. Option C, 78%. Option D, 63%. The correct answer is option C, 78%. Loan minus to minus value is calculated by dividing the loan amount by the appraised value, $163,799 divided by $210,000, or about 78%. The other percentages confuse equity with LTV or use an incorrect numerator or denominator. Question 16. Jamie wants to pay a sponsored Illinois licensee, Harper, directly for help with a purchase. How should compensation normally be handled? Option A. The buyer may pay the licensee directly at any time. Option B. The title company must split the fee directly with the licensee. Option C. The licensee may accept a secret bonus if the transaction closes. Option D. The sponsored licensee should receive compensation through the sponsoring broker. The correct answer is option D. The sponsored licensee should receive compensation through the sponsoring broker. A sponsored licensee is normally compensated through the sponsoring broker rather than directly by the public. Direct payment, title minus company fee splitting outside the broker relationship, and secret bonuses create licensing, disclosure, and compensation problems. Question 17. A property manager named Drew collects rents, screens tenants, arranges maintenance, and accounts for owner funds. Which duty is most central? Option A. Managing the property in the owner's interest while properly accounting for funds and records. Option B. Guaranteeing that every tenant will renew. Option C. Commingling all rents with personal funds. Option D. Ignoring fair housing laws during screening. The correct answer is option A. Managing the property in the owner's interest while properly accounting for funds and records. Property managers owe duties tied to the management agreement, owner instructions, legal compliance, and accurate accounting. They cannot guarantee renewals, commingle funds, or ignore fair housing requirements while screening tenants. Question 18. During a first substantial discussion, Harper asks Kendall whether the brokerage represents the buyer, the seller, or both. Why should the relationship be clarified early? Option A. The relationship is irrelevant until after closing. Option B. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. Option C. A broker owes no duties until a deed is recorded. Option D. Agency disclosure is needed only for commercial leases. The correct answer is option B. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. Brokerage relationships determine duties such as disclosure, confidentiality, obedience to lawful instructions, and care. Waiting until closing, tying duties only to deed recording, or limiting disclosure concepts to commercial leases would leave the consumer without important relationship information. Stressed about your Illinois real estate exam? We can take Illinois real estate exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A broker representing Blair receives confidential negotiating information. Which duty is most directly triggered? Option A. Revealing all confidential strategy to the opposing party. Option B. Changing the purchase price without permission. Option C. Protecting confidential information unless disclosure is authorized or legally required. Option D. Ignoring lawful client instructions. The correct answer is option C. Protecting confidential information unless disclosure is authorized or legally required. Agency and brokerage duties include protecting confidential information while also making required disclosures. Revealing strategy, changing terms without authority, or ignoring lawful instructions would violate core client-service duties. Question 20. A buyer asks about neighbors dislike a former occupant, but there is no physical defect or legal restriction affecting the property. Why may this be treated differently from a material defect during Jordan's Aurora vacant lot file review? Option A. Every rumor must be included in the deed. Option B. The broker must create a structural inspection report. Option C. The seller must lower the price by statute. Option D. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. The correct answer is option D. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Stigmatized property issues generally differ from material physical defects or title/legal problems. Rumors do not belong in a deed. Brokers do not create structural inspection reports, and statutes do not automatically set a required price reduction for a stigma. Question 21. A study question asks whether an interest is leasehold estate. What is the candidate being tested on during Casey's Evanston rental duplex file review? Option A. The nature and duration of rights held in real property. Option B. The amount of commission owed to the broker. Option C. The mortgage interest rate. Option D. The required size of a residential disclosure form. The correct answer is option A. The nature and duration of rights held in real property. Estates and land describe the nature and duration of property rights. Commission, loan interest rates, and disclosure minus form size are separate topics and do not define the estate itself. Question 22. A buyer is reviewing required environmental paperwork involving known underground storage tank concerns. Why are these disclosures commonly tested during Morgan's Oak Park lakefront cottage file review? Option A. They guarantee the property has no environmental condition. Option B. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. Option C. They replace the purchase contract entirely. Option D. They require the broker to perform engineering tests in every sale. The correct answer is option B. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. Environmental disclosure laws are designed to inform buyers about known or potential risks before or during the contracting process. They do not guarantee a problem-free property, replace the contract, or require brokers to perform technical engineering tests in every transaction. Question 23. A buyer wants to operate a retail shop in a residentially zoned property in Decatur. Which issue should be investigated before closing? Option A. Whether the deed automatically changes zoning. Option B. Whether the broker can override the ordinance. Option C. Whether zoning permits the intended use or whether an approval such as a variance is needed. Option D. Whether title insurance guarantees business income. The correct answer is option C. Whether zoning permits the intended use or whether an approval such as a variance is needed. Zoning controls land use, so the buyer's intended use must be permitted or approved through the proper local process. A deed, broker preference, or title insurance policy does not automatically change zoning or guarantee business income. Question 24. Drew and Hayden both claim the same earnest money after a failed Illinois purchase contract. How should the broker view disbursement during Riley's Elgin Commercial Suite file review? Option A. The broker may give the money to the latter party. Option B. The broker must always keep the money as commission. Option C. The buyer automatically receives the money regardless of contract terms. Option D. The broker should follow the contract, written instructions, or lawful dispute-resolution process before releasing funds. The correct answer is option D. The broker should follow the contract, written instructions, or lawful dispute-resolution process before releasing funds. Earnest money disputes require careful handling under the contract and applicable escrow rules. A broker cannot choose based on pressure, convert the money into commission without entitlement, or ignore the party's contract rights. Question 25. A business offers to find apartments for renters in exchange for a fee. Why might Illinois licensing law be implicated during Avery's normal farm parcel file review? Option A. Rental-finding services can involve regulated real estate activity when performed for compensation. Option B. Rental-finding services are always exempt regardless of activity. Option C. Only sellers can trigger licensing law. Option D. The service becomes legal if no written records are kept. The correct answer is option A. Rental-finding services can involve regulated real estate activity when performed for compensation. Rental-finding and leasing-related services may be regulated when performed for compensation. The activity is not automatically exempt, licensing law is not limited to sales, and failing to keep records does not cure an unlicensed activity issue.